Bon, si vous voulez poser quelques questions, il est déjà 10h30. En général, on essaye toujours de tenir le timing, mais on peut très bien répondre. Là, il sera ravi de répondre si vous avez une ou deux questions. Voilà. Ou plus, au choix. Vos questions. Voilà.
It was crystal clear. That means I did a good job, right?
Confrère.
S'il vous plaît, Olivier Lecomte. Est-ce que vous pouvez nous indiquer fiscalement comment vous traitez les comptes payable on death bank account, c'est-à-dire les comptes ouverts et pour lesquels on dit qu'ils vont bénéficier directement à telle personne?
Vous comprenez la question? Ok.
Excuse me. Oh, here, maybe I do the...
Oui.
I have my little translators in there just to make sure I understand it clearly because I don't want to give you wrong advice. Okay.
Est-ce que vous pouvez nous expliquer comment fonctionnent fiscalement les comptes ouverts au profit d'un bénéficiaire qu'on appelle les payable on death bank accounts? Non?
Est-ce que tu peux venir t'approcher pour faciliter? Tu peux venir. Voilà, super, bien.
Oh, now I hear it.
Yes.
Okay.
Sorry.
Bon, alors,
Est-ce que vous pouvez...
Okay, thank you.
Can you
Okay.
explain me, please?
Oui, je comprends maintenant.
Ok. Est-ce que vous pouvez m'expliquer comment fonctionne fiscalement, hein, non pas civilement, les comptes avec bénéficiaires, qu'on vous appelez en Amérique les payable of death bank accounts?
D'accord. Okay. The payable on death bank accounts, very common in the US. It's sort of like you name a beneficiary of a life insurance policy. You can name a beneficiary, and it goes paid directly there. Same thing with the bank account. In the US, they're called payable on death or transfer on death, POD, TOD. Those terms are used interchangeably. You can name a beneficiary of a bank account. So let's say father has a bank account worth $1 million in the US, and he does a POD designation to his daughter who's going to school at NYU. What happens? Well, it goes to daughter, right? She's the one who gets it, regardless of what his will says. It ignores the will. It goes outside of probate. It goes directly, just like a life insurance policy, directly to that named beneficiary. You ask, what's the tax consequence? You go back to all the rules I started talking about before. You say, okay, is the decedent a U.S. person or a U.S. domiciliary or a non-U.S. domiciliary? Does he have exemption amount or non-exemption amount? Is it a U.S. situs asset or is it a non-U.S. situs asset? Bank accounts in the U.S., by the way, even without a treaty, U.S. bank accounts are exempt from U.S. estate tax. So that transfer, regardless of the treaty, can pass to the daughter tax-free and go directly. And that's because under US domestic law in the Internal Revenue Code, it says bank accounts in US banks are not subject to US estate tax. Contrast that to if it's a money market account at a brokerage company. That is subject to US estate tax. But a bank account in a US bank is not subject to US estate tax at death for anybody, any foreign person. Regardless of the amount, there's no limitation. They can have $20 million cash sitting in a US bank account and they die, it can pass to anybody and there's no US tax because it's a specific exemption in the Internal Revenue Code for bank deposits. They want foreign money into the US, and that's the reason. However, if that same taxpayer owned US stock and died with stock, or the money market account, it is subject to US tax. Unless under the treaty, you can re-situs it back to another country like France under the treaty, so you can get around that issue. Any other questions?
Donc ceci n'est pas un joint name account, c'est autre chose. Ce n'est pas un joint name account, c'est un... Voilà, donc c'est un compte avec désignation du bénéficiaire.
Exactement.
D'accord. Et si la somme d'argent est recueillie par une personne qui n'est pas résidente ou qui n'est pas de nationalité ou résidente américaine, malgré tout, ça reste non taxable aux États-Unis.
Exactement, si c'est dans une banque.
Pour autant que ce soit des liquidités et pas des valeurs mobilières.
Exactement.
D'accord, ok,
ouais.
Merci.
Pour revenir...
On a le micro. Il n'y a pas un micro quelque part?
Sorry. According to what you stated about the accidental American citizens, what do you advise to people who have both French and American nationality, but who live mostly in France and have most of their interest in France, more of their assets in France, because it seems to be more difficult to have both nationality. I know there's some people who are refusing the American nationality because of that, because it's more expensive, because they have no benefits.
Right,
if they just go to the US for vacations, or they don't intend to live there one day or another.
Right. Okay, so yes, you raise a very good point, and I see it all the time in practice, and that is, for those who didn't hear in the other room, the accidental American, or somebody who is a US citizen, either because born in the United States or by attribution. So if they're born to an American abroad, like little Prince Archie is to Meghan Markle, the new princess, right? We have the same issue. He's a US citizen, and he can't say he's not a US citizen. It's not like he accepts it when he turns 18. He is a US citizen. So you have those that are accidental Americans, if you want to call it that. Now, it's pretty evident that he is a US citizen. Some may not know it, you know, they didn't realize that because they were born outside the US, that they're citizens just because their parent was a US citizen. So that can be problematic, or the US citizen that was a US citizen by birth in the US, but is also French. And what do? You know, there's many banks, we know that many French banks, Swiss banks, foreign banks do not want to deal with American citizens or even green card holders. And under FATCA, they have to look for certain indicia. Do they have a US cell phone number? Where were they born? They have to look at that. They ask them, fill out a W-9 or a W-8 to see if you're declaring if you're a US person or not. And so, but the banks, in doing their due diligence, have to look at these issues, and oftentimes are closing down their accounts, right? They're like, we don't want to deal with FATCA compliance. So it can be problematic for a foreign individual, a US person living in France or outside the US. And they have to do they have to report every single year. They have to report their worldwide income, even though they have not stepped foot in the United States for 30 years. But for those 30 years, if they had income, they had to report it in the US. They have a foreign bank account, they have to report it in the US. All of that, the compliance burdens are tremendous. So I totally agree with you. Many Americans are trying to expatriate. They relinquish their US citizenship. The problem with doing that without getting advice first is they may be subject to the US exit tax, which is a mark-to-market tax on their worldwide assets. And remember, the mark-to-market tax on, let's say, their home in France, property they may have inherited from their French parents, all of that is going to be exposed to US exit tax, which is a deemed sale, so 20%. Plus the 3.8%. They're not living in a state, so you don't have the state tax. It's really harsh. And somebody had, for example, a retirement plan that's taxed under it, that may be immediately subject to US income tax. It can be, which is 37%. So it's a very, very harsh tax unless you can get out of it. Some people can get out of it. Why? They don't hit the threshold. Their net worth is under $2 million. They've been fully compliant, filing their tax returns for the last at least 5 years. And they don't have an US income tax liability in excess of a 5-year average of $150,000. So if they're sort of on the lower scale of net worth and income and they are compliant, they can expatriate without getting hit with the exit tax. If they're over that, by the way, if they're married under a community property marital regime, 50% of all of the couple's wealth is counted toward that $2 million. So that may throw somebody over, even though, you know, the US citizen may not have in her name $2 million worth of assets. If her husband has $10 million and she has a community property marital regime with him, she's deemed to own $5 million. She's subject to the exit tax on the community property that's titled in her husband's name. So it can be really, really problematic. Let me mention one last thing, because it's another trap. a long-term green card holder who does the treaty tiebreaker election under the US-France income tax treaty is deemed to have expatriated and is subject to the same rules. It's not just US citizens giving up citizenship. It also applies to long-term green card holders who are green card holders for more than 8 out of 15 years, and they treaty tiebreak exit tax. Devastating. A very bad situation, especially when they didn't expect it. So it's a filing position that French accountants should know too. Be careful. Now, if they're born dual nationals, may I just mention this? There is also another exception under the Internal Revenue Code. Somebody who's born a dual national of the US and another country and is resident of that country at the time of expatriation is not subject to those thresholds and can expatriate without the exit tax. But there's a few other qualifications, like they could not have lived in the United States for a certain period of time and all of that. But they may be eligible for that example that you just said, where somebody's lived 30 years in France and they were born a dual national. They may be able to expatriate without that exit tax, but they really need to take legal advice and examine those particular circumstances to see if they can get out of the exit tax.
Merci beaucoup. Est-ce qu'il y a d'autres questions? Bon,
just to get back to the form of wills, what kind of will forms would you recommend for a cross-border US-French situation? Let's say, would you recommend international will or not?
Yes,
Would
generally
it be more broadly accepted in the different US states?
Absolutely. So
anywhere or
within the United States, yes.
Yeah.
So generally speaking, it's better to, now the Washington Convention is adopted state by state, so not all of them have adopted it, but generally if you have two witnesses and a notary, then it will be uniformly accepted. So, but it has to be, witnessed, signed at the bottom generally of each page. So those are generally the requirements in the United States. But following the international will certificate is usually a good idea. Furthermore, if you have a dual cross-border situation, and they are electing now under Brussels IV, the law of US nationality, they should have a US will, right? If they're saying US law is going to govern, they should be having a US will drafted under the jurisdiction whose law is going to apply to their worldwide succession, including their assets in France. And then that will would be given, of course, to the French notaire here to dispose of any French assets in accordance with US law of nationality, if that was their election, if they elected that.
And would you recommend separate wills, one for the US side's assets and one for the French assets? Or is it something that...
No, I've actually, because I have many US-French cross-border clients, and so I've asked that, and some notaires, I've gotten different answers. Some notaires have said just use one will to apply for everything. It's going to be simpler. We can administer it. It's no problem. It's going to be translated anyway, so just use the one US will governed under the law of New York or wherever the decedent was resident or had the closest ties. Some say, no, do a separate one just to use for the French property, mimicking what the US will says. But then what if there's some sort of, so there's two schools of thought. So I leave it up to the notaire that we're working with to kind of guide on that, whichever notaire that we're working with. But generally speaking, since Brussels IV, it's usually a single will.
Je pense que si le testament qu'on fait en France a vocation à s'appliquer aux États-Unis, le testament international de la Convention de Washington est probablement le meilleur conseil.
Oui.
You confirm
On
this,
prend le
hein.
son parce que-
Et si dans ce testament on prend des dispositions qui peuvent s'appliquer aux États-Unis, il faut bien entendu faire valider ce testament par un juriste américain.
Oui,
Ce
c'est
serait
bien
quand même
d'avoir,
mieux. C'est
oui,
mieux d'avoir un
d'être
avis quand même,
confirmé.
hein.
Oui,
Oui.
exactement.
Voilà.
Oui.
Ok.
Je m'excuse.
Bon, écoutez, merci beaucoup.
Merci
Alex,
beaucoup.
Merci, hein, c'était
Merci, enchantée.
pas facile de nous expliquer ça. Hein. Merci mille fois. Donc, vous recevrez les slides en anglais et la version française. Voilà, j'ai dû retoucher parfois la version française parce qu'il y avait des petites erreurs. Donc, si il y a une difficulté entre les deux versions, bien entendu, vous vous attachez à la version anglaise.
And if anyone
Voilà.
has any questions, don't
Merci.
hesitate to reach out by email or phone. I try to be very accessible. So thank you very much for giving me this opportunity. I'm delighted. Thank you. Merci.